Hello, everyone. I'm Leonard French, your favorite copyright attorney, and I did not forget my hat. I have a hat. I just wanted to make a more dramatic entrance with it. So, without further ado, thank you very much to. Oh, I forget whether it was Carl or who sent this hat, but this is the new hat that I'm going to wear for today's stream. You are not synced. Way out of sync, video looks behind audio. How about now? If I switch to a different microphone, how's the sync now? I'll give it about 30 seconds before I continue with anything substantive because I don't want to. I switched to a different microphone, so check. 1 2, check 1 2. Better. Now it's better. Yes, perfect. Okay, I will continue. Hello, everyone. I'm Leonard French, your favorite copyright attorney. And today I thought I would talk about this update in the Harmony Gold case. This is the Robotech versus Battletech case that really no one knows exactly what's going on with, because so far all we've seen is a... Do you really have to eat that now? All we've seen so far is a complaint that says that some of the mechs look similar, but I'm not 100% sure that the violations were that egregious. They seem to be mechs that aren't being publicized, but who knows? I mean, there's very possible that Harmony Gold could have all the evidence, and we're just waiting to see the evidence come forth. So I'm not going to go out on a limb and speculate that Harmony Gold has no evidence, but I'm not seeing the strongest of cases here unless they can, directly prove the things that they've directly said. So, I mean, that's a court case, so duh. Okay, everyone. So let me bring it up on the screen here. This is what we're talking about. This is the docket for a different case. This is not Harmony Gold versus Battletech versus what's his face, Joshua Wiseman. Yes, this is Harmony Gold versus Tatsunoko Productions, who are one of the original parties, I think, that sold the rights to Harmony. I don't remember. You have to remind me from the last week's stream, because frankly today's been a very long day, which is why I'm here on the live stream a little bit late. So thank you very much for joining me there. But this is the Harmony Gold versus Tatsunoko Productions case, and it was filed on the 14th of August, and the first thing that we see is it's a petition to confirm an arbitration award and for an entry of judgment. So I pulled up that document. That looks like this. Hang on, there is a box. There we go. Get rid of the box. This petition to confirm an arbitration award. What is an arbitration award? Well, arbitration is when parties try to settle something out of court, but they can't agree, but they really do want to settle out of court, but they can't agree, so they ask some third party to help them. Sometimes it's through an official organization like the American Arbitration Association. Sometimes it's through your local bar association and you hire an attorney called a mediator. Sometimes you hire a panel of attorneyators to act as mediators. In one or two cases that I've seen that were more interesting in this sense, the one party hired their mediator, and the other party hired their mediator, and then the two parties chose one mediator between them, and those three mediators decided the case. So this is the result of an arbitration hearing award thing. There was already some kind of informal trial, probably still following some kind of rules of procedure and all that, and rules of evidence. But this is the result of that procedure, and so now the parties have to go to court, or at least the most interested party would go to court and have the court enter this arbitration award, this either a damage award or finding of facts, and then the case can proceed from there. You need to do this for a couple reasons. One, the arbitration award is just basically a contract, and a contract is not enforceable without doing more, right? So you went through all this procedure and you didn't get something that's enforceable in court without having to further go to court. But if your arbitration procedure is correct and your parties consented to it and everything, you could skip a lot of court headache by going through this. So that's what they've tried to do here, I think. I have not read this, so we're going to have an adventure together here, everyone. Petitioner Harmony Gold, by and through its undersigned counsel, brings this petition to confirm an award, arbitration award, dated June 28th, 2017, in connection with arbitration proceedings between Harmony Gold and Tatsunoko Productions. This is root beer, non-alcoholic, just FYI. I do not drink or anything on stream. The parties, Harmony Gold is a corporation organized and existing under the laws of the state of California. Tatsunoko is a limited company organized under the laws of Japan, principal place of business in Tokyo. Jurisdiction is diversity of citizenship, which we can go over in another video, but that's one of the enumerated ways that you can sue somebody, especially across state lines, is through diversity of citizenship, and you have to allege exactly what they say here, that the amount in the case in controversy exceeds $75,000. If you are currently a law student, you will get to know that number a little bit. You'll have to remember for the bar exam that the number is 75 plus, not 75. So if you get one of those trick questions that says, what is the amount in controversy, and one of the multiple choice answers is $75,000, that is not the correct answer. It is $75,000 and 1 penny. So factual allegations. I'm sure we're all much more interested in this. The parties entered into a license agreement March 15th, 1991. Which governs the parties' contractual relationship. The parties subsequently entered into a number of amendments to the license agreement. One of the amendments, dated August 6, 1998, contains an agreement to arbitrate any dispute between the parties. Okay, so now we know a little bit about why we're here. The arbitration provision in the 98 amendment states this amendment and the main agreement shall be governed by the laws of the state of California. Okay. Shall be resolved by binding arbitration in California pursuant to the rules of the American Film Marketing Association, has since become known as the Independent Film and Television Alliance. And so they are the group that is, or those rules at least, are the ones governing the dispute. The dispute arose between the parties regarding rights under the license agreement and its subsequent amendments. Harmony Gold subsequently submitted an arbitration demand on November 23, 2016, and Tatsunoko submitted a cross-complaint December 29, 2016. February 2nd, Jack Friedman, Mr. Friedman Esquire, was designated as the arbitrator. So there you go. Both parties submitted opening and responding briefs along with voluminous exhibits to Mr. Friedman on May 2nd and 9th, 2017. The arbitration hearing took place before Mr. Friedman on May 16th, 17th, 18th, and 19th, so 4 days of hearing in Los Angeles. Mr. Friedman permitted the parties to present extensive evidence and argument. Remember, this is Harmony Gold arguing this. After the close of arbitration, each party submitted a post-hearing brief and a request for attorney's fees and costs on June 5th, 2017. Based on the arbitration briefs, evidence presented, exhibits, relevant case law, and argument, Mr. Friedman issued a detailed 21-page arbitration award on June 28th. And yes, we are going to take a look at that. A true and correct copy is attached. This petition is timely filed. Yada, yada, yada. So whereas Harmony Gold prays for the following relief, that the court enter an order confirming the award and the court enter judgment on the award in the form of the proposed judgment. Actually, I did not download the proposed judgment, so let me take a moment here, if I can, and grab it. Proposed. I don't have a... Oh, it does. A proposed judgment is not there. Where is the proposed judgment? What I'm talking about is this docket here should show a proposed judgment. And I must just be missing it, or it does not. Yeah, this is an application to file under seal. That is not the proposed order. However, I guess we can take a look at the arbitration document itself. Exhibit 1. Redacted version of document proposed to be filed under seal. But first... Oh, sorry, no dogs. I guess we'll come back to the dogs. In the matter of arbitration between Harmony Gold and Tatsunoko Production Company, this matter duly came... Oh, this is an award. This matter came before me on hearing March 16th, 2017, 9 a.m., Jack Friedman, arbitrator, claimant's offices. Okay, so at Harmony Gold's offices, as agreed by the parties, continuing through and concluding on May 19th, 2017. Harmony Gold was represented by counsel. Tatsunoko Productions was represented by counsel. Also present were a bunch of lawyers, vice presidents, legal assistants, more lawyers, more administrators, directors. A record of the proceedings was done by Sarah McDonald of Veritext. And actually, not that I'm not like a spot, like Veritext doesn't sponsor me or anything, but I also use Veritext for my depositions. James Studer, thank you very much for the $5. This hat was donated, I want to say by, I forget. I want to say it was Carl, but I don't want to get it wrong. Shepard Gray. Not Carl, by Shepard Gray. So thank you very much, Shepard Gray. Where was I? Claimant and respondent were afforded the opportunity to appear and present their cases with 4 percipient and 3 expert witnesses testifying under oath. I actually have never seen that word before, so I am going to look it up real quick. Having good understanding of things. Percipient. Having good understanding of things. I swear, I've read things for 37 years. I've never seen that word before. That is impressive. Over 600 documents were introduced into evidence, including agreements, communications between the parties, expert reports, audit reports, other relevant documents concerning issues relating to this arbitration. On June 5th, the parties filed closing briefs and the matter was submitted for decision. Background. Oh, a Murloc hat would be awesome. No, I'm not putting my address in there. Agreements. This arbitration arises out of a license agreement entered into between the parties, claimant as licensee and respondent as licensor thereunder. Dated March 15th, 1991, wherein licensor granted licensee the exclusive and irrevocable right to exploit 3 Japanese animated television series known as A. Macross, B. Moss PETA, someone please yell at me if I'm mispronouncing that, and C. The Southern Cross, same. Subsequently, the parties entered into an amendment to the 1991 licensing agreement dated August 6, 1998, extending the term for an additional 10 years through March 14, 2011, and a further amendment to the 1991 license agreement dated June 28, 2002, extending the term to March 14, 2021. Additionally, another amendment was entered into on January 20th, 2003, related not to the term, but wherein it was provided that, for good and valuable consideration, the receipt of which is hereby acknowledged, licensor hereby grants licensee whatever rights licensor has, if any, in the copyright of the original 36-episode series Macross. though the validity of this agreement is contested by respondent. Lastly, there was an amendment dated March 20th, 2008. These agreements, along with other related but less relevant agreements and amendments subsequent to the 1991 license agreement, are herein referred to as the operative agreements. You got that? Did everybody follow that? Because I was even having a little bit of trouble. Where I got stuck is right here, where it says, for good and valuable consideration, licensor... Let's see, it's just claimant is licensor. Claimant is licensee. Respondent is licensor. Okay, so let's clear this up. Where's my text? I need to make a new text thing on the screen. Claimant is not Harmony Gold. Claimant in this paragraph is Tatsunoko. Respondent licensor is Harmony Gold. So, for good and valuable consideration, the receipt of which is hereby acknowledged, Harmony Gold, claimant is licensee, yes, so Harmony Gold is the licensee, and Tatsunoko is the licensor. Am I getting this right? Somebody please help me with this. Respondent, licensor, respondent, licensor, respondent, Tatsunoko, licensor. Okay, Tatsunoko is licensor. For good and valuable consideration, the receipt of which is hereby acknowledged, Tatsunoko hereby grants to Harmony Gold whatever rights Tatsunoko has, if any, in the copyright of the original 36-episode series Macross. That's in 2003. And that looks an awful lot like a quitclaim deed. And if you're a law student, you might know what a quitclaim deed is. If you don't know what a quitclaim deed is, that's perfectly normal. A quitclaim deed is when you transfer property, but you don't know how much property you own. And I don't mean the area of the property. I mean, you don't know if you own it outright, if somebody else owns part of it with you. Maybe there was a divorce maybe there was some family history that was lost or something, and you have no idea whether this property was sold or not, whether somebody else out there has a deed that beats yours. So sometimes you just write a document, an instrument, a deed that says, I give you what I got. And when it's sort of like an as-is kind of thing, you got this property from me, but if it turns out it's not mine, you're up a creek. That's your problem. So that's what this is. Tatsunoko granted Harmony Gold license for whatever they had in the original 36 series episodes, or 36 episodes of Macross. Got it? Okay. Prior to entering the 1991 licensing agreement, Tatsunoko granted various rights to the programs to Harmony Gold, a Hong Kong company, commencing... Wait, let me parse this language. Prior to entering into the 1991 license agreement, Tatsunoko granted various rights to the programs similar to those in the 1991 licensing agreement to Harmony Gold Limited, a Hong Kong company, HG Limited, commencing with an agreement dated September 11th, 1984, which superseded a deal memorandum of the same date, even an earlier agreement on January 15th, 1984, with regards only to rights limited to merchandising for Macross. Regarding only rights limited to merchandising. Followed by numerous amendments and related agreements up to 1989, which rights under the original agreements will ultimately transferred and assigned by Hong Kong Harmony Gold to claimant, who would be... Hang on. Claimant is Harmony Gold USA. Wait, I've gone too far. Hong Kong Harmony Gold to claimant in 2 steps, first in late 84 and then in late 85. This arbitration deals primarily with the operative agreements. However, reference to some or all of the original agreements, as the parties have done, may be beneficial to grant the relief requested and or serving to inform understanding, or to make the case freaking complicated. It is especially noteworthy that it was pursuant to the 1984 licensing agreement that the derivative works listed in B, A, B, and C below were produced by licensee. And licensee, again, was Harmony Gold, USA. Okay, so has everyone got that, or do we need to go over that about like 10 more times? I think I need to go over it about 10 more times. But let's continue. Produced derivative works were initially in English. The underlined produced derivative works should mean something. I'm guessing it's the produced derivative works. Were initially in English, based on the programs pursuant to the original agreements. Robotech 85, Robotech 2, 86, Robotech 2, 88, Shadow Chronicles 2006. Also, non-motion picture derivative works such as comics, video games, and books. 1985 Robotech consisted of 85 television episodes using no new footage. 1986 Robotech was a movie using additional third-party footage, some new animation, and a new story. 1988 Robotech consisted of a 3-episode animated sequel to the earlier Robotech productions, released in '90 as a feature, not episodically, written by claimant with new animation contributed by respondent. 2006 The Shadow Chronicles, an animated sequel to earlier Robotechs as a continuation of the Mospita story, contained all new footage. This evidence showed that none of the Macross underlying programs, characters, or visual depictions thereof were included therein. All of the aforementioned produced derivative works are referred to collectively herein as Robotech, or by their individual date title. Unproduced derivative works include the following option development deals for live-action motion pictures: 2007 with Warner Brothers and 2016 with Columbia Pictures. So we could have gotten a Robotech movie in 2007 or 2016, and we didn't? Is that what I'm hearing? Oh, that's sad. Parties history. Kenji Yoshida and Ippei Yuri, founders and co-founders of licensor Tatsunoko, and their trusted executive Koki Narushima, have been dealing with licensee founder Frank Agrama for over 33 years regarding the programs and other matters. Tatsunoko's founders retired over 12 years ago after they sold their company to a Japanese toy company, Takara, in 2005, which was again acquired in 2014 by Nippon Television. Mr. Narushima, having been at Tatsunoko starting in 1980, ultimately became president and CEO in 2005 under new owner Takara, until 7 years ago, in 2010, when he also retired. Mr. Narushima, still living in Japan, provided at claimant's request a declaration in this matter because his age and health prevented him from traveling to this arbitration. Imagining this redacted portion might say something about his health that might be very personal. I'm not sure. Excuse me. Procedures. The 1998 agreement provides that it and the 1991 license agreement will be governed by the laws of the state of California, and that all disputes shall be resolved by binding arbitration. According to the rules for international arbitration published by the Independent Film and Television Alliance, previously the American Film Marketing Association, which rules therefore applicable to this matter are those in effect on the effective date of the contract, rules dated May 27, 1997, which establish the authority of the arbitrator hereunder. With respect to the procedural requirements pertaining to this matter, I find that the arbitration of this dispute between the parties was properly initiated, responded to, etc. Arbitrator duly noticed and held a preliminary hearing February 16th, wherein, among other things, counsel presented their oral arguments following written pleading and on the issue of the proper parties. After full consideration of the parties' argument, a ruling was issued by the arbitrator on February 18th declaring that claimant and respondent were the only proper parties to this arbitration and that Hong Kong Harmony Gold was not a proper party. A ruling was also issued by the arbitrator on May 3, 2017, after argument by the parties, permitting a declaration by Koki Narushima to be admitted into evidence, stating that it will be up to the arbitrator to determine the proper weight to be accorded the declaration, taking into account all other evidence or relevant circumstances. Surprisingly, the declaration was introduced by and for the benefit of claimant, not respondent, for whom Koki Narushima had worked. It should be noted, for the record, that in the fall of 2013 a request was made by respondent to amend and restate the operative agreements, which request was not accepted by claimant, as in its view, doing so would have drastically reduced its rights. An audit was then demanded, and when completed on July 7, 2016, the respondent filed an arbitration which was withdrawn to attempt mediation on November 9th and 11th of 2016, which mediation failed to reach an accord. Facts, claims, and analysis. Relating to the various claims, counterclaims, and defenses, the following is a summary of certain facts found by the arbitrator to be true and relevant to the decision. Any differences between this summary and either of the parties' positions or contentions are the result of the arbitrator's determinations as to witness credibility, relevance, burden of proof considerations, and the weighing of the evidence, both oral and written. In addition, based on the documentary evidence, witness testimony, and arguments of counsel, the arbitrator hereby provides the following analysis relating to the sought-after relief. Does this sound very confusing? I think we're about to get into the meat of it. So all of that, what have we been going for 35 minutes here? I think all of that is basically introduction. Big West litigation. In or around 98, Big West, a Japanese animation company who along with Studio New had co-produced Macross with Respondent, asserted that it, not Respondent, owned the exclusive rights to make sequels based on Macross, which, if correct, would have denigrated rights licensed to claimant Harmony Gold. The court ruled for Respondent in 2003 as confirmed in 2005 by the appellate courts, except for finding that Big West owned exclusively the original visual depictions of 41 characters used in the Macross program. This substantial victory for Respondent left it in breach of its representations and warranties to claimant in the operative agreements, wherein it had represented that the rights granted would not infringe in any way upon the rights of third parties. Derivative rights, including live-action rights and exploitation rights. In the original agreements, Respondent granted claimant the exclusive right, so Tatsunoko granted Harmony Gold the exclusive right to make and exploit derivative works based on the programs and to use the characters and stories contained therein. Those rights were exploited by claimant, and it's making the derivative works and sequels listed in B, A, B, and C herein above. In the 1991 license agreement, substantially a renewal of those rights contained in the 1984 license agreement provides, licensee is entitled to present, etc., and otherwise adapt and prepare derivative works based on, advertise and otherwise dispose of or exploit the underlying series using any methods or devices of exploitation. Emphasis added. This language is clear in that it granted derivative rights of all kinds, including live-action rights, not just animated derivative rights. The grant is express, broad, and absolute, not limited in any way to only animated derivatives. Excuse me. Further confirmation thereof was evident in Respondent's awareness without objection, let alone encouragement of that process, as well as by providing a legal opinion affirming that such production as contemplated would not infringe upon the rights of Big West. Despite respondents being aware of claimant's attempts to make a live-action derivative, the respondent never demonstratively asserted that claimant did not have live-action rights until this controversy arose. So, seeming to get into the heart of the matter, it looks like there's a third party that no one's mentioned up till now who has rights to the original Macross drawings, and maybe Tatsunoko didn't have the rights to give away that they said they did. Additionally, as both in the 1984 license agreement and 1991 license agreement made the parties joint copyright owners in the programs, that licensee was also authorized to prepare derivative works based on that ownership. The operative agreements also granted broad rights of exploitation of those works as follows. Licensor hereby grants exclusively and irrevocably to the licensee the rights to exploit the animated television programs, which rights include, but are not limited to, television broadcasting, merchandising, theatrical, non-theatrical, video devices, sound recording devices, and publications. Respondent argued, respondent is respondent is Tatsunoko. Tatsunoko argued that the board exploitation, I think that's a broad, that the broad exploitation grant was limited in its effect due to the inclusion of the words "on the terms and conditions set out below," and that paragraph 9 of the agreement, which limited licensors' adaptation work on the programs only to the extent that it be done in a reasonable manner so as not to detract from the programs, somehow limited the broad grant, but it does not. Paragraph 9 is only one of the many terms and conditions of that agreement that clarify but do not restrict the broad grant of rights. Merchandising rights are granted, but they must be compensated for. The intention to grant basically unlimited exploitation rights is reinforced by the 1998 agreement, which, stating that it irrevocably extends the grant of exclusive rights from the 1991 license agreement, in that such exclusive rights shall include all rights in all media now existing or hereafter invented, excluding only the merchandising rights in Japan, including but not limited to theatrical, non-theatrical, television, video, merchandising, soundtracks, and publications, and excluding only merchandising rights in Japan. Tellingly, that exclusion is the only restriction on the rights granted. Therefore, claimant, for example, would have had the right to exploit a live-action motion picture by theatrical or other of the ways so listed. So claimant Harmony Gold has the right to make a live-action motion picture of the original Macross stuff, or at least they thought they did. Then Big West comes in and says, wait a second, I've got the copyrights to these 41 originals that are more original than your originals, so now you owe me money, I guess, for using them. Assignment rights. Additionally, the 1991 license agreement gave licensee the right to assign, license, delegate land, etc., etc., etc. It also provided that even if the agreement were to be terminated, pre-existing licenses entered into by the licensee shall not be disturbed in any way. Sequel rights granted, taken away, and reinstated. The 1998 agreement relinquished claimant's rights to make sequels to the programs, which was granted to it in the 1991 agreement. This was to eliminate the possibility that Big West could claim the respondent was infringing on its rights during the pendency of the dispute. In the 2002 agreement, claimant's sequel rights were restored in Mospita and the Southern Cross. Thank you, Joshua Walker, for the $10. Very much appreciated. A 2003 agreement, then restored, granted the right to make derivative works of Macross. It was signed by Koki Narushima, who was then, as stated above, the president and CEO of Respondent, Tatsunoko Productions, and thus had actual and apparent authority to bind his company. Respondent asserts suspicions about the coming into existence of this agreement, but suspicions alone are not enough to discredit the same, and the elements upon which a claim of fraud would rest upon are unproven. The signature was not forged and was signed by both parties in or around June 2006, as evidenced by claimant's transmittal thereof to its counsel, Leonard B. Roseman, who was involved at that time in various related matters for the company. Additionally, additional evidence of its authenticity comes into the subsequent 2008 agreement, which listed that document in its preamble recital of all prior operative agreements, which was vetted as testimony confirmed by respondents' stringent internal review procedures prior to approval and signature. This amendment was negotiated between 2005 and 2006, but was backdated to 2003 to coincide with the approximate date of the trial court decision in its Big West litigation. Thus, pursuant to the 2003 agreement, respondent Tatsunoko granted to Harmony Gold all of its remaining rights in Macross, including derivative and sequel rights, but naturally excluding any right to create derivative works using the 41 original characters from Macross, which now belong to Big West. The seeming inexactitude language regarding the 41 original characters may have been inartfully drawn, but was intended to track the decision in the Big West litigation so that licensor Harmony Gold USA, or licensor Tatsunoko, was giving up everything it owned to Harmony Gold USA licensee. The arbitrator has been mindful throughout of the the voice evidence, the spoken evidence rule, parole evidence rule, that the rule doesn't permit extrinsic evidence when there is clarity in contractual terms, which is largely the case in this matter. In other words, you are not allowed to bring in outside evidence of discussions or such when the contract is clear in its four corners, especially if the contract says so in its language. Exploitation of digital media, such as internet streaming or video of demand of Robotech, were also expressly permitted under the operative agreements. Sublicense of clips and music. The 1991 license agreement gave claimant the right to exploit the program's music, soundtrack, all other components. Home video rights are not part of merchandising. The original agreements and the operative agreements granted the right to exploit Robotech in merchandising, video, and otherwise. Specific royalty payments were set forth in detail for such exploitation by way of merchandising. None were delineated for exploitation by way of video, nor, for that matter, for exploitation by way of television, or the many other possible means of exploitation that were authorized. The reason for that is no separate payment was negotiated or agreed for rights granted to be exploited other than for merchandising. The license fee was to cover, for the specific term, the right to produce and exploit the programs in new works for all purposes except that additional consideration was to be paid for merchandising. The video or home video rights are terms of art, that video or home video rights are terms of art understood in the motion picture industry to be separate and distinct from merchandising rights such as toy, game, and etc., are axiomatic, meaningless. The parties' various agreements do not change that meaning. The 1991 license agreement provided that the license fees were for TV and other visual rights in all media now existing or hereafter invented. Other than an almost All right, I'm back, I think. Hang on. Okay, sorry about that. Yeah, I figured out how to stop it doing that, and now it's back to doing that again. So we'll just have to remember to reset it every half an hour. Other than an almost 30-year-old fax from Frank Agrama equating the two, video and merchandising, the parties' subsequent relationship reflects otherwise. And while licensee produced testimonies substantiating the view that the licensor produced no witnesses adverse to this understanding. Throughout the parties' history, they negotiated specific and separate payments for video and merchandising when they saw fit to do so and were clearly capable of distinguishing the two. Here they did not do so. Until this arbitration, the respondent never objected to not receiving home video royalties. Thus, the parties' conduct and specific contractual language require the conclusion that under the operative agreements, the license fee was a flat fee that covered all television and all other visual rights, including home video, carving out only a separate calculation and a payment for merchandising. Legal fee expense offset against royalties, $541,000. Due to the Big West litigation, respondent asked claimant to enforce and protect the Macross trademarks outside of Japan, which included analyzing and tracking said litigation, traveling to Japan, and providing documents and advice in support thereof. The parties agreed that claimant would deduct such costs, including legal fees, from future royalties and might become due to respondent. This offset was not reduced to writing, was orally agreed to and confirmed by the parties' conduct over many years, culminating in a documentation thereof in 2009 by Harmony Gold USA after a meeting in Los Angeles between Frank Agrama and Koki Narushima. As further corroboration of respondent's knowledge of these costs and the recoupment arrangement, respondent attempted to recoup these legal fees from Big West and sought a declaration from claimant assisting them in this regard. The 1998 agreement gave claimant permanent exclusive copyrights and trademarks in all materials it created or utilized from the programs. Quote, all trademarks, copyrights, and other rights in any materials created or utilized by claimant in connection with the exercise of its rights, including but not limited to the name Robotech, shall be exclusively owned and controlled through the universe in perpetuity by claimant. Claimant is accused of infringing respondent's copyrights in the programs. The operative agreements and claimant's actions based thereon do not support such a claim, because the claimant, as an exclusive licensee and joint copyright owner of the works in question, cannot, as a matter of law, infringe. In this case, an exclusive licensee cannot be liable for infringing the rights of copyright conveyed to it, nor can a co-owner be liable to the other for infringement thereof. Additionally, pursuant to the agreements and its various actions over many, many years, claimant's registering of copyrights was in furtherance of its rights. Beginning in the summer of 1999, claimant Harmony Gold began to register trademarks related to Robotech solely in its own name, which it was permitted to do so by the 1998 agreement. Doing so was affirmed by respondent over the years. Also, respondent's claim for cancellation of the Macross and other trademarks fails because such marks are presumptively valid after 5 years of continuous use and no fraud has been proven related to their use and registration, which might otherwise have avoided this bar. Statute of limitations. Claims made by respondent therein may be barred by the statute of limitations, considerations, or denied for other substantive reasons as discussed here, or both. As an example, if claims were asserted relating to the deal with Columbia Pictures that they would not be time-barred having occurred in 2016, but would nevertheless be denied based on the arbitrator's determination that production and exploitation of live-action rights were authorized. Also, the legal fee offset would be both time-barred and denied for substantive reasons. Here, statute of limitations considerations alone are a bar to most of the audit and or other claims and causes of actions proffered by Tatsunoko. A cause of action for breach of contract accrues at the time of breach, which then starts running of the limitations period. Claims based on a written contract may be sought only within 4 years from their occurrence, so the statute of limitations on contracts is 4 years. Such a period may be extended or told only in limited cases where one could not, with reasonable diligence, have discovered its claim earlier. Here, respondent had actual or constructive knowledge to establish its claims, knew of the release of Shadow Chronicles in 2006, knew of the Warner Brothers live-action deal in 2009, and failed to do so until filing demand for this arbitration in July of 2016. And they failed to audit and or request royalty statements in a timely manner. All but $988,000 of respondents' claimed damages are time-barred and have been incurred more than 4 years before respondent first sued, as they had knowledge of the facts necessary to make their claims earlier. While not a statute of limitations statutory issue, it should be noted that the 2002 agreement, the respondent acknowledged, quote, "The licensee has fulfilled its obligations to date under the 91 and 98 agreements, and thereby waives claims prior to." The 1991 license agreement entitled respondent to make an audit each 12 months, yet it only chose to exercise that right for the very first time in over 3 decades in 2015-2016. Said agreement did not require claimant to provide participation statements, but respondent Said agreement did not require claimant to provide participation statements, but respondent, until just prior to this arbitration, never asked for them. It should be noted that even if claimant had contractually agreed to provide royalty statements, such agreement, as is customary in the industry, would have established a cut-off date for objections to the same of 1 year or 18 months from submission, wherein claims made thereafter would be barred. Respondent should not be in a better position than if the operative agreements made provisions for royalty statements. It should be noted that licensee, without request, regularly sent detailed information to licensor about its accrued royalties, including sending a formal royalty statement in October 2005. Yet despite normal follow-up, licensor never chose to audit or sue until now. By permitting the audit, the claimant did not waive any of these defenses, including its right to assert the statute of limitations, as it reserved all defenses when it consented to the audit. Furthermore, simply permitting an audit did not revive claims that were time-barred before the audit began. Are you with me? So far, it sounds like Tatsunoko sued Harmony Gold for alleged violations of the merchandising part of its agreements, and then Harmony Gold, they went into arbitration to figure out what the rights are, and here's been the result of that. So, wow. 3 of the various audit claims are adjusted as follows. Sub-licensee Toynami royalties were properly accounted for over the years. $1.2 million claimed in the audit were not for royalties owed, but rather for loan payments or investments by licensee in some kind of startup. As to Robotech.com receipts, a full royalty was paid once to licensor on the merchandise, and a second royalty on the same merchandise would not be warranted when and because they were resold. And C, when and because they were so I guess Robotech.com, okay, so merchandising on Robotech.com was allegedly getting double accounted for by Tatsunoko, I guess. As exclusive holder of the license in and to the programs, having paid a contractual fee for the rights granted, licensee, Harmony Gold, is entitled to sue for infringement of its own rights and has no obligation to share with licensor any recovery therefrom. Then there's a investment in claimant's company and infrastructure and production costs for Shadow Chronicles in exchange for participation of claimant's share of revenue for a participation. A sharing, I guess, of claimant's share of revenue therefrom. This was not, as claimed by respondent, revenue earned from exploitation of the Shadow Chronicles, as to which respondent might have otherwise been entitled to share. There's more claims here. Claims justified, $43,000. Derivative production rights after expiration of the term. The 1998 agreement provided that, notwithstanding anything to the contrary in the 1991 license agreement, all trademarks, copyrights, and other rights in any materials created or utilized in connection with the exercise of these rights shall be exclusively and owned and controlled throughout the universe in perpetuity by Harmony Gold. Among other things, claimant believes that the above-quoted language grants them the right to continue to produce and exploit derivative works of the programs in perpetuity. Among other arguments, claimant relies largely on the belief that utilized includes the programs, but that is contrary to the interpretation established by respondents' proofs that same referred to third-party property, not the programs. Arbitrator finds that claimant's license in the programs does expire on March 14th, 2021, as does their rights to produce and or exploit works based on any of the programs. From the very beginning of the parties' relationship, they were dealing with finite terms that required additional consideration to be given for extension of rights granted. To allow the use of the programs beyond the term without payment of consideration for renewal thereof would be totally inconsistent with the parties' course of dealing over many, many years. The 2002 agreement extended the term of license on the programs, all three, since the reference therein is to paragraph 4, which is related to all of the programs, until March 14th, 2021. If the parties, in accordance with the operative agreements, do not reach an agreement to extend, then claimant would no longer have the right thereafter to produce and or exploit any product containing the programs or any part thereof. This conclusion is additionally supported by the Stewart via Abend case, cited and relied on by respondent, and the 1976 Copyright Act. The arbitrator has reviewed and or considered the pleadings, witness testimony, exhibit books, documentary evidence, post-hearing briefs, and the numerous arguments presented by the parties, their legal theories, and reliance on statutory and case law, including those not specifically addressed above, all of which have been carefully considered in reaching a decision, and now makes the following determinations. Award. Declaratory and other relief granted in favor of claimant Harmony Gold. To the date hereof, claimant has not materially breached any agreements with respondent related to the programs, nor infringed any of respondent's rights therein, including but not limited to infringements on respondent's copyrights or fraudulently registering Macross trademarks. So Harmony Gold's not the bad guy there. The original agreement and operative agreements grant claimant the right to make derivative works of the programs and Robotech, including live-action motion picture adaptations, and claimant has not produced any unlicensed works. The 2003 agreement is valid and binding on respondent, and claimant has been granted therein all of respondent's copyrights in Macross, except for the visual depiction of the original 41 animated graphic characters from the underlying program pursuant thereto. The operative agreements grant claimant the express right to sublicense its rights as it chooses, and claimant has neither breached said agreements nor infringed on respondent's rights by entering into such sublicenses. The operative agreements grant claimant the express right to exploit the programs and any derivative works in all media, including digital, and claimant has not breached said agreement. The operative agreements grant claimant the right to exploit the programs and any derivative works through sublicensing of music and clips. Claimant owes no royalties for home video exploitation pursuant to the 1991 license agreement. Claimant has had the right to offset royalties otherwise owed to respondent in the sum of $541,362, incurred by claimant in connection with the Big West litigation until recouped. To the date of the last royalty statement or audited date, claimant has fully accounted for all royalties owed to respondent except for the amount of $42,543, which claimant is to account for and pay to respondent forthwith, subject to any continuing proper offsets. Respondent's audit and other claims are identified in the body hereof, and respondent's request for relief are time-barred as they arise out of claims more than 4 years old. As of this date, respondent is not entitled to terminate the operative agreements or otherwise curtail claimant's rights thereunder. Harmony Gold claimant owns in perpetuity the title Robotech and the produced Robotech programs with exploitation thereof subject to respondent's rights on termination of the operative agreements. So, to summarize the first part there, Harmony Gold owns all the rights that we've been talking about. that they basically won that part of the dispute. And they have the right to continue to produce derivative works and to continue to exploit the existing works until 2021. May? Whatever that date was. Which I suddenly can't find. March 14th, 2021. Relief granted in favor of respondent Tatsunoko Productions. Harmony Gold's right to use the programs expires on March 14th, 2021, along with any extant sublicenses, as all rights to the programs revert back to respondent at that time. Upon expiration of the term of the operative agreements, the claimant no longer has any right to use or exploit derivative works produced during the term, which contain portions of the programs, as rights to the programs revert back to the respondent at that time. So everything goes back to Tatsunoko on March 14th, 2021, which is a little less than 4 years away. Claimant has no permanent, exclusive, and irrevocable copyright and trademark rights in the programs, as same shall belong to respondent on expiration of the term in 2021. Upon expiration of the term, respondent shall have the right and option to disaffirm, cancel any existing licenses, assignments, or other agreements extending beyond the term, as may have been entered into by claimant with others granting any rights to the programs. Claimant is to pay to respondent the sum of $42,553,000 as the result of the audit, subject to any remaining proper offset rights due to the Big West legal fee expenditure, which we don't have a number on that. So who knows if that money is actually due or they just take that off of a spreadsheet somewhere. The award of all costs of the arbitration is to be determined in the sole discretion of the arbitrator and in accordance with paragraph 14 of the rules, as the operative agreements do not provide any guidance. At the closing hearing on May 19, 2017, the arbitrator advised the parties in writing that legal fees are to be reasonable and directly related to arbitration, but need not be the same for each firm, as, for example, pay scales, attorneys, etc. may be different. The arbitrator determined that it is appropriate to consider only costs relating directly to this arbitration. Thus, the arbitrator finds that claimant, as the predominantly prevailing party, is entitled to recover from respondent such costs as adjusted by the arbitrator in the total amount of $848,000, which consists of claimant Harmony Gold USA's legal fees allowed by the arbitrator as being reasonable, in the amount of $711,000, and claimant's costs of $137,000, which include its share of both the IFTA filing fees of $1,100 and your arbitrator's fees of $25,612. This award is in full resolution and settlement of all claims and counterclaims submitted to this arbitration. All claims and counterclaims not expressly granted herein are hereby denied. This award may be executed in any number of counterparts, etc. Signed, Jack Friedman, sole arbitrator. So what do you think of that? Holy mackerel. That was very complicated. That was very, very complicated. It was so complicated, we're going to go put dog video back on. I don't even know where the dogs are, so I'm going to go find them in the video. There they are. Okay. So, yeah, that was really freaking complicated. So, Big West had some rights. Tatsunoko sold off rights that they didn't have. No, don't close OBS. Thank you very much. Tatsunoko sold off rights they didn't have. They got caught up in that. They corrected that in 2003. Then it sounds like Tatsunoko didn't do anything for about 10 years, and then someone recently was like, hey, we should sue Harmony Gold for all this stuff they're doing. And it sounds like Tatsunoko didn't fully understand or wasn't fully clear about their licensing agreement with Harmony Gold. The other half of that is, if Tatsunoko if their relationship with Harmony Gold has now soured, they can revoke everything on March 14th, 2021. So, yeah. So that's that. What do you think about that? I'm going to turn to Brandon for questions. I see there are a lot of you here. Okay, Tao, thank you for letting me know about the out-of-sync issue. I know that it's not perfect, but... Okay, so do we have any questions? Battletech and MechWarrior... I think Battletech and MechWarrior are safe, but this case was not about that. I was hoping that this would answer questions about the Battletech and MechWarrior cases with Harebrained Schemes and Piranha Games. And this did not answer any of those questions. Except one, maybe like why now? This might be the answer, why now? Because Tatsunoko started some kind of action with Harmony Gold, and Harmony Gold probably started the action with Harebrained Schemes as a result of all of this. So maybe the Harebrained Schemes and Piranha Games litigation would already have been going on anyway, but maybe it also got started because Tatsunoko was pressuring Harmony Gold about this stuff. So this is a very comprehensive arbitration award. No, it was definitely not easy to parse and understand, but I think we got through it in an hour, and that honestly isn't bad for a law school lecture. So, how did you enjoy that? What does this mean for the HBS case? Exactly. A couple people are asking for a recap. I thought I just did one a little bit ago, but let's try again. So Tatsunoko, I believe it was Tatsunoko, was the original creator of basically the original works that led to Robotech, which were Macross and Mospita and Southern Cross. And then Tatsunoko licensed those rights to various entities, and this whole reading for the past hour was trying to understand what in the world were all those relationships. So finding out those relationships between all these different parties probably isn't the fulfilling part. What you probably want to hear was that Tatsunoko licensed some rights to Big West and then licensed those same rights to another company, Harmony Gold. And then there was a lawsuit in the 90s, and that was resolved, and Harmony Gold apparently owns everything in the US except for those 41 original drawings. And then Harmony Gold has been exploiting Robotech for the past, 20 years. More than 20 years, 30 years. But Harmony Gold then continued for 20 years to exploit the works, and now Tatsunoko somehow got it through their head that they were owed some additional money or something, so they initiated some kind of action or audit or something, and then Harmony Gold said, screw this, and started an arbitration proceeding, and then I'm speculating after that, I think it was filed against Harebrained Schemes and Piranha Games. So it sounds to me almost like Harmony Gold is not the bad guy here. I mean, I know a lot of people were really up in arms about Harmony Gold suing Battletech, but it sounds an awful lot like Harmony Gold was in some kind of legal trouble with Tatsunoko, and it wasn't their fault. Separately, Harmony Gold is also suing Battletech and MechWarrior Online, Piranha Games, and Harebrained Schemes. So I'm just going to have to treat that as separate. I don't know what infringement there was there. I did not do and could not immediately see a legal analysis as to how you figure out which mechs look like other mechs. I mean, it's like saying that a camera, a DSLR digital single lens reflex camera, shouldn't look like it has a grip on one side and a lens on the front. I mean, they all got to look like that. That's what a digital single lens reflex camera is. So a mech, a bipedal, anthropomorphic mech has got to look a little bit like a person. So at what point does it become copyrightable? When I add some little drawings on the thing, or when what? Like, how much detail do I have to add before that becomes copyrightable? So the standard is access and substantial similarity. They obviously had access, so we just have to go through the substantial similarity analysis. Mr. Minty Fresh Smell, that was the TLDR. Sorry. That actually was the TLDR. Oh, okay. So how is plaintiff going to prove Battletech 3D objects are the same as 2D objects, even if they look similar? Honestly, that usually has to go to either a judge or a jury, and they have to be given stuff that we haven't even seen yet. They have to be given evidence and testimony to look through, understand, and then they will weigh those understandings whether they fit a definition of substantial similarity or not. I don't have any more guidance for you. You're going to be looking at two things and making a judgment call. And if the jury comes up that they feel that the material is substantially similar, then Harmony Gold wins. That's really it. I mean, there's more to it than that, but that's the simplified version. Any update on the John Oliver and Murray Energy case? No. I haven't heard anything about John Oliver and Murray Energy in the past 2 weeks since I did my last update with the ACLU's thing. If you haven't seen the ACLU's update, I have a video out. Go check it out on my channel. The ACLU filed a brief. It's kind of epic. Even if you don't like the ACLU, it's still kind of epic. Flash frames. So in regards to mech designs from Macross, does Harmony Gold have those, or do those fall into Studio News rights, given it seems as though the 42 characters from the original Macross may cover those designs? So it seems like Harmony Gold owns absolutely everything from Macross except those 41 original designs that belong to Big West. What that means, how that plays out, I don't know enough about that to speculate. How often, to your knowledge, has the phrase "throughout the universe" appeared in a legal document of any kind, much less licensing rights? I do not use that term in mine documents, but honestly, that's a pretty cool phrase. It's not a bad phrase. The point of the phrase was to convey the meaning to both parties that all rights were granted everywhere. So you could say that about a dozen different ways, I'm sure. Probably even more than a dozen different ways. But no, I've never seen that before. Oh, sorry. Didn't mean to throw you off, Brandon. What is the purpose of plaintiff posting a bond when requesting a TRO? Noticed this in the Imagos case and other cases. Yes. So in the Imagos case, we were required to post a bond, and the LeVar Burton Reading Rainbow case, which I will cover this week, probably tomorrow, they also had to post a bond. They did also get their TRO, and LeVar Burton cannot say, but you don't have to take my word for it. He can't say that anymore. So they got their TRO, I got our TRO. The point of the bond is, what if we were wrong? What if we either lied or the evidence was wrong? Because the TRO does not require the opposing side to have notice and an opportunity to respond. Because we are violating their due process rights, and because we're violating them, I'm asserting for good cause, in the Imagos case, for example, if we're wrong and that good cause does not exist, ultimately, you're paying for the due process rights of the defendant. The bond is held by the court, and I get the money back. Well, the client gets the money back when the court considers the TRO moot and the bond no longer necessary. Do judges have any way to punish reprimand for overly long complaints? It seems like this one took way too long to say what should have been said. Yes, they do. Judges do have rules about how long, not opinions, but how long certain filings can be. Usually it's 21 or 26 pages. This one's 22 pages. This is also an award, so this one doesn't have any rules. It will be as long as it needs to be, and I've seen judgments that were hundreds of pages long because they were that complicated. My hat is falling off. Hey, get back up here. Anyway, so no, there's no limits on the judge or the award or the filings, but there on the evidence. There are limits on the writings of the parties, their filings, the pleadings, their briefs will have page limits. If I could be any root vegetable, what root vegetable would you be? I don't know. You've stumped me. I want to say a rutabaga. I don't know what that is, but it sounds funny. What's wrong with saying most unique? Well, aside from unique generally not being a spectrum, unique generally means one of a kind, so to be able to say that something is more unique than something else is a little weird. That's about all that's wrong with it. I don't think there's anything like, it's not like it's like I think it makes sense if I said this cup was more unique than this cup. They could both be unique, but one could be more precious to me than the other, but that's just subjective. So I think maybe that's it. The thing that's wrong with saying most unique is that it's subjective. Feel free not to answer that one. Okay, so what do we think? That sounds like a great place to stop the stream without going too much further. So thank you all for joining me. I do have a Twitch gaming channel. We play a lot of PUBG on there. I'm going to go throw the ball in the backyard for the dogs for a little while, and then I'll probably be playing a little bit of PUBG. Oh, yes, I have to eat. I haven't eaten anything all day yet, so yes, I would like to eat first. So I'll probably be back in an hour or so with with some PUBG on stream. So anyway, I love you all. I want to thank all of my supporters. Let me pull up all of their names. I know that New Sensei is eagerly awaiting the video that he has paid for. New Sensei has sponsored... Wow, there is just so much going on. New Sensei has sponsored a video, The Basics of Copyright for YouTube Creators. I'm still working on that, but it should be out this week. So thank you very much to New Sensei for all of that sponsorship. Anyone who would like to sponsor at that level, the minimum to ask me to produce a video is a $500. On Patreon we do it by the month, and you're not paying $500 a month. It's a $500 one-time fee if you would like me to produce a video for your topic and with your name as the official sponsor and everything like that for that video. So if you have any ideas that you would like to have me produce, you're welcome to support at that level, and I'll produce your video. We can also make other arrangements, that are not Patreon if that's not your thing, but that's about the approximate sponsorship cost that I'm looking for to produce your video. Thank you for the $50 a month supporters: Joshua Meinziger, Baxorn, John Cripps, Nate Beck, John Steele, Weston Loney, and Lydia Collinson. Those are my $50 supporters for August. Very much appreciated. And my $5 plus supporters are scrolling on the LED panel behind me and should be in the description below at some point if they're not already. Yes, thank you very much, Gisenja, for the cheers. Yes, I think a drink sounds like a wonderful thing to recover from this. Okay, yeah, Captain. About 45 minutes, about an hour, and I think we'll be on stream for PUBG. So thank you everyone for joining me. I'm going to stop the stream from YouTube now instead of stopping it on my console here, where I know it doesn't work that way. So thank you for joining me. I'm Leonard French, your favorite copyright attorney. I'll see you on my Discord server, which should also be somewhere in the description below, or on Twitter. I do have a Facebook, but please don't be offended if I don't accept your friend request if you're not an in-real-life friend of mine or a regular online friend of mine. If we're just getting acquainted, get to know me a little bit, and then we can talk about being friends on Facebook. So thank you, everyone. I'm Leonard French, your favorite copyright attorney, and I will see you in my next video. Have a great Sunday. Have a great week. Love you all.